It's Tuesday. It's March 18th. I can't believe it. And today we are back in court for the Commonwealth of Massachusetts versus Karen Read. There's a lot more hearings on the docket today. We are going to be starting with the court giving an oral ruling. I was stalking the docket yesterday. So we're getting a ruling from the bench on the ARCCA experts.
So first we had full hearing from counsel.
We did have a full hearing.
I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read
my
that
notes
transcript.
are barely open at this
and
point.
I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here.
Wow. Oh, she's still pissed. She's not wrong about the candor. We'll see what she does from here. It just needs to be the same energy for all the lawyers. Let's just keep going.
There has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate...
That's not good for the defense. That payment was made and Attorney Little put in the motion that they were not paid for.
And transparent attempt to keep exculpatory
I need to change my glasses.
Of neutral expert witnesses from reaching the jury in this case. The next page.
And they did correct the record on that, but they
the
filed
Commonwealth
it.
Accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control.
Yikes.
Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation, that it was deliberate.
Deliberate's a problem.
I find that there is a flagrant violation of the Rule 14 obligations.
Strong words.
And before I decide which sanctions are appropriate,
she's going to let them talk?
Defense counsel and Ms. Read at sidebar, I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Read before I figure out exactly what I'm going to do here. So there's no greater constitutional right than the defendant's right to a fair trial.
Yes.
Including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Read. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so... Because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself.
Oh, shit.
But Ms. Read does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential.
That's a
It's
big
the bedrock
warning.
obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word.
It's true.
And I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time.
Oh, God, she's just using his words against him.
Commonwealth, I am denying your motion to exclude the ARCCA witnesses.
Okay, there it is.
Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan.
Principal's office.
I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that.
So the courts allowing the ARCCA witnesses to testify have given a public tongue lashing to the defense and reminded them that she is displeased, but stopped short of sanctioning the defense, did not remove Alan Jackson from the case, and is allowing the witnesses to testify. So what was this? A scalding?
I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts.
I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic.
With about a half day in court for hearings on the Karen Read case that mostly comprised the motions in limine, I was surprised at the end of the morning before the court took the break for the day that the defense has formalized a motion to continue the case and that the court has not dismissed it out of hand. We heard from the Commonwealth's appellate attorney. The defense asked that the court consider moving that April 1st trial date start back. No date was stated, but continuing the case to allow the defense's appeal to the First Circuit of the denial of the habeas regarding Karen Read's right against double jeopardy to be fully vetted out by the appellate courts before this trial starts. The appellate counsel for the Commonwealth said in court that there was an accelerated briefing schedule and that what would be ideal is to allow the appellate process at the First Circuit to complete or conclude before going forward with this trial, but it is the Commonwealth's position that they do not want to continue the trial. The court made an interesting note on the record saying that the court's biggest concern is the jury selection and impaneling a jury because of the amount of recent publicity, or at least that's what I took away from the court's statement. And I wonder if the court would also like to push back jury selection and this trial to have a little bit more distance from quote unquote recent publicity. And yes, There will always be publicity, but the court has granted a essential gag order now. So you aren't going to have new interviews with the defense unless they are pre-existing. You're not going to have new statements. So the fact that a 3-part series is coming out on HBO Max or whatever, this close to a trial starting, could cause problems with jury empanelment. So getting a little further out in time may help, it may not. So it seems that the court is also concerned about how close this trial is to starting and is giving the attorneys an extra day to have some of those conversations. It seems to me that the court's at least considering whether or not pushing back the start of this trial is what's best for everyone. Because again, if the worst case scenario that's going to be going through the court's mind is you start this trial, it takes you weeks to impanel a jury because everybody's heard about this case recently and has thoughts. And then you have a jury trial completed. If there is a not guilty verdict, then it stops there. If there is a guilty verdict and then the Court of Appeals comes back and says that there is a double jeopardy issue, the result to that would be a new trial on just count 2, potentially. So then you've got the potential for yet another retrial, depending on what's decided by the Court of Appeals. That's kind of the worst case scenario for the court, is you have to do a 3rd trial when allowing the Court of Appeals to decide would forestall that worst case scenario. Of course, the Court of Appeals could come back and say, no, we're not granting this appeal. No, this isn't an issue. Go forward with the trial on all 3 counts. But if they don't, and the trial has gone forward and there are convictions, the remedy to that is oftentimes go back and do it again on just count 2. And the court, I don't think, wants that possibility looming out there, but we will see. So the court has asked the attorneys to essentially meet and confer about the appeal. The court has asked the attorneys to talk about the jury questionnaires. We still don't have a ruling on the motion to dismiss, and we are coming back to court on Thursday. They went through quite a few of the motions in limine that we saw ruled on during the first trial. I think the court's rulings will be fairly consistent. We also saw the lingering motions that had not been argued yet regarding the Commonwealth's neurosurgeon expert, and the defense arguing to limit the testimony of that expert not to the manner of death, but to the mechanism of injury, and in the alternative to have a voir dire. We know that there are going to be new experts in this case. We are seeing that new experts for the Commonwealth and the defense are going to be a thing in this trial. We've also seen the attorneys' rough estimates for this trial, with the Commonwealth saying that with full court days, Monday through Friday, they would expect about 3.5 weeks for their case in chief, and the defense saying on the outside they would need 2 weeks for their defense. But of course, that's going to depend on how evidence comes in. It could be less than that. So we're looking at maybe a 6-week trial instead of a 10-week trial of evidence. And that, of course, doesn't include the amount of time it takes to pick a jury. Last time it took, I think, just about a week, like 5 days of jury selection. And there's been more publicity since. Jury selection might take longer. So we might also be looking at 2 weeks of jury selection, which will not be streamed. So will the court continue this trial? I don't know. The beginning of the day started with the court strongly admonishing the defense about statements made regarding the ARCCA experts. The court hadn't made a ruling on that yet. And at the beginning of the hearing today, the court found that the defense made deliberate and flagrant misrepresentations to the court at sidebar and in a written motion regarding payment to the ARCCA experts. The court then had a sidebar discussion with Karen Reed and her defense attorneys about what she was going to do with that. And at the end of the day, the court said, do not misrepresent things to the court, but did not sanction the defense in a monetary way, did not remove a defense attorney, and did not prohibit the ARCCA experts from testifying. The court made a very strong record and voiced their displeasure. It was very much a calling to the principal's office of the defense, and then ultimately denying the Commonwealth motion to forestall the ARCCA experts from testifying, and again, reminding the defense that all of their discovery needs to be turned over. And I know the question's going to be, what about the Commonwealth's discovery? We're not on those motions yet because the court has not ruled on the motion to dismiss yet. And I'm curious to see what the court says about the evidence that the Commonwealth hasn't turned over to the defense. We also heard argument today regarding the motions to keep out any allegations or assertions or discussion of witness intimidation, and discussion about how that came in the first trial, where the Commonwealth did agree that that was not the appropriate topic area of questioning unless the defense opened the door for it. But the dramatic back and forth between the defense and prosecutor Brennan definitely showed that both of them are going to push each other's buttons and aren't going to shy away from calling one another out in court. So that between the attorneys was not commented on by the court, but I was sitting there going, we're all just bringing it up a notch, are we? And then at one point, Attorney Jackson said, I think we can just bring the drama down a little bit. I don't know if that's going to be possible in this case, but we will be back in court for this case on Thursday at 9 a.m. Eastern. Of course, I will be starting a bit after that. A, it's early. B, I like the Zoom room. C, we got to let our West Coast friends be awake for all of it. The big things that are outstanding really are the motion to dismiss, and now this question of a continuance, which I think is a possibility here. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.